To bring anyone up to date that did not see the prior video, which is linked below, I ordered a saw online to be picked up from Menards. I used the pick service, which cost me extra for the convenience, because they only had one saw in stock of the model I wanted. After being directed to 3 different places for some inexplicable reason, I was then told to exit the store and redirected through the lumberyard entrance to re-enter the same Menards building from the back. On exit, they wanted to open my trunk to see if I had stolen anything while in the lumberyard. I refused. Long story short, I ended up in handcuffs in a police car where I was told I would not be released until I consented to a criminal search of my trunk. I refused. Officers then went after my wife, who was the passenger in my car, and they coerced her into opening the trunk under threat of arrest. We sued in federal court. I learned on December 14, 2017, that the court dismissed the claim. The court stated that we had no plausible claim to justify the lawsuit. Here's a brief synopsis of the order. I'll be as even-handed as possible and say that the facts recited in the background are misleading to the point of crafting a narrative. In addition, the case citations used have been misconstrued and in some cases simply reworded for convenience of the court's argument. Examples of this include that the court entirely omitted the fact that the refusal to provide physical ID only occurred after being told that the officers would get a warrant to search my vehicle. At this point, officers also already had my name from the 911 call. The fact that they mentioned a warrant changed the entire tone of the encounter with police. I was now considered a suspect in a crime that no one had accused me of. The court went on to note that Officer Alyssa Newberry, now Officer Alyssa Smith, made comments to my wife such as, "It would be doing us a huge favor," and "Would you be willing to?" in order to suggest consent. But the reality was she coerced my wife to open the trunk. The court entirely omits that prior to Officer Newberry saying this, the same officer told her,
I mean, it's up to you. Do you want to go home and have him go home today? Because if I can verify who he is, and if he would just verify his product, he could just go.
The court omits also that my wife asked to speak with me before opening the trunk, and she was not allowed to. Regarding the seizure, and throughout the order to dismiss, the court states that in what is known as a Terry stop, officers may make a brief investigatory detention. And that's true. But there are 2 problems here. First is the word brief. My detention was, in fact, indefinite in nature. My release was entirely predicated on my consent to a search I had no intention of consenting to. And it was made clear by both police and Menards I would not be released until I consented. There can be no argument of brevity in what was, by all measure, an indefinite detention. Second, this was not an investigatory detention at all. It was, in fact, retaliatory and punitive. There was no investigation conducted whatsoever. There was no investigation into the initial call of false imprisonment, and there was no investigation into shoplifting. Upon arrival, police simply made demands of me, and when I refused, they handcuffed me and placed me in a squad car. They said I would stay there until I did what they wanted. The court argues that my refusal to consent to a search, along with my refusal to ID myself, amounted to reasonable suspicion. There are 2 inherent problems with the court's theory. First, the refusal to consent or cooperate can never be used on its own as a legal justification to detain or seize. This was found in cases such as Florida versus Bostic. And second, my refusal occurred only after I was in fact seized, and as such, it cannot be used as justification for the seizure that occurred prior to the refusal. The court claims that we failed to establish that Menards was what is known as a state actor, for the purposes of proving Menards in fact violated my civil rights. However, a private party who willfully participates in joint activity with the state or its agents is considered a state actor. Menards employees and management clearly were engaged in joint activity. Police were in fact enforcing Menards' policy.
And that's where reasonable suspicion comes in.
This is their policy.
That's their policy. That has nothing to do with me.
This is their policy.
Ma'am?
And Menards employees in fact searched my trunk after removing me as an obstacle. Furthermore, if police fail to make an independent investigation and simply follow the will of the merchant is considered a state actor. And that was clearly the case here. Police simply demanded compliance with Menards' policy. They detained me until I complied with Menards' will. There was no investigation at all, just a strong-armed intrusion into my trunk. The court claims that Madsen's conduct in his assault and battery was justified in part because I had been issued a trespass warning. Force has to be justified with something, such as a lawful order that is not complied with. However, the video record, as well as Officer Newberry's own supplemental report, clearly confirm without ambiguity that I was not given the warning until I was returning to my vehicle. And this was after the battery by Madsen.
I was just physically assaulted trying to grab her, trying to even look for a badge number on this gentleman.
As far as the excessive force by handcuffing me, the justification of the court was literally, of course handcuffs hurt, so it can't be excessive force to use them. Well, a punch in the face hurts too. The question is not whether it hurts. The question in excessive force is whether the force used was arguably appropriate for the situation. The court goes on to dismiss false imprisonment against Menards, essentially claiming that in order for a false imprisonment claim to exist against Menards, that Menards would have to instruct police to arrest me. According to the finding by the court, Menards can keep you chained up in their basement indefinitely and not run afoul of false imprisonment laws, just as long as they do not tell police to arrest you for a crime. Also, in dismissing false imprisonment against Menards, the court finds that I was not arrested by officers. This is of course irrelevant to a false imprisonment charge against Menards for their own actions, but I digress. Police ordered me from my vehicle, searched me inside my pockets, handcuffed me only after clearing me for weapons, and then placed me in a squad car. They conducted no investigation whatsoever while I was detained, and the detention was indefinite. By every measure, this was a de facto arrest. Furthermore, the court claims Menards detained plaintiffs only long enough for police officers to arrive and conduct their own investigation. But Menards did no such thing. They said in so many words that I was not leaving until I opened up the trunk. They did not say I couldn't leave until police arrived.
You can talk to the man.
I'm not pulling anything. I'm informing you of the status of the law.
Furthermore, the security guard was yelling for officers not to bother coming out, that doing so was wasting their time.
He's wasting your time, officer.
What the Menards security guard was doing was literally interfering with a 911 call, a gross misdemeanor under Minnesota law. The court dismisses the intrusion upon seclusion claim, stating that we failed to demonstrate that Menards and police were unaware they lacked personal or legal permission to enter my trunk. They can't argue personal permission, but as far as legal permission, police require probable cause for a criminal search, even under the motor vehicle exception to the warrant requirement. They did not have probable cause, nor did they ever claim to have it. If police had arguable probable cause, they could have simply forced the trunk open. They did not. They demanded consent. They knew they lacked the legal permission to search, which is why consent was vital to give them the legal permission to do so. As far as Menards, they've been warned by the Iowa Court of Appeals that this kind of action is unlawful, as it amounted to false imprisonment to demand a search to exit the lumberyard. This is well covered in Zahn v. Menard Incorporated. Everyone involved, police and Menard Incorporated, knew full well that they lacked any legal permission to enter my trunk. That is precisely why each required the other, to create essentially a paradoxical chicken and egg scenario that neither could legally justify on their own. We are appealing this order to dismiss, and I have every confidence that an appellate court will overturn this dismissal, but the fact that a federal judge could make such determinations and craft such a narrative should be enough to give anyone pause. Please hit a like and subscribe, and I'll be updating with new videos as the case progresses. Peace to everyone. Thanks for watching.